Tonight, calling on the experts, cell phone data taking center stage.
Based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
The new evidence from the night John O'Keefe died, including the temperature of his cell phone. Plus,
you were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things.
A tense exchange between the Commonwealth and crash reconstruction experts. Why their relationship with the defense is under the microscope. And denied. The Supreme Court passing on Karen Read's appeal. What happens next? Canton Confidential, the Karen Read murder trial, starts now.
All right, for a mere half day for the jury today in court, but there was plenty that happened there in Dedham. Good evening, everyone. I'm Melody Mendez. I was at Norfolk Superior Court, I should say, as the trial and the testimony picked back up this morning. And very first, and the only witness that the jury heard from, in fact, was a digital forensics expert. And as you're about to see, cell phone data, as analyzed by this witness for the prosecution, could prove pivotal to the Commonwealth's case against Karen Read. Take a look. The first and only witness called before the jury Monday, Ian Whiffen, a digital forensic examiner. The focus of the first part of his testimony was on Jennifer McCabe's cell phone and the now infamous "Haas Long to Die in Cold" Google search. Whiffen testified the search actually happened after 6 a.m., so after John's body was found in the snow. The defense team and their expert in the first trial testified the search was made at 2:27 a.m., hours before John's body was found. According to Whiffen's testimony, McCabe was searching for something else on her phone at 2:27 a.m. and left the browser tab open. He says the data shows that when she reopened the tab later at 6:23 a.m. to make the Google search in question, it had the same timestamp of when the browser was originally open.
I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
Next, Whiffen focused on data pulled from John O'Keefe's phone. 3 areas specifically: the victim's location, his health app, and the temperature of the phone's battery.
And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time.
This could prove critical since the defense team claims O'Keefe entered Brian Albert's home at 34 Fairview. The data shows O'Keefe's phone logged him as climbing up and down stairs at 12:22 a.m. Whiffen says Apple Health can show a person as having climbed stairs when they're simply driving up a hill while holding their phone.
And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill.
Using location data, Whiffen also testified that O'Keefe's phone never went near the driveway of the home.
Based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
All right, so joining us now is our chief legal expert, Michael Coyne, and of course, our Sue O'Connell courtroom insider. Thank you both for being with me, or I should say, thanks for letting me be with you tonight. I want to dive deeper into this testimony because it's huge, right? We were told to expect new evidence last week, and that's exactly what this witness served up. New evidence. His name is Ian Whiffen. He is from Cellphone, that phone extraction company. And he took data, he broke down data from John O'Keefe's cell phone from the day of his death, including information from a health app, his location using Waze, and even the temperature of the cell phone's battery. So what stood out to each of you most and why?
I thought it was very powerful, and it was the science. Finally, we're really digging deep into the science. Yeah. He's very impressive as he lays out the case for the Commonwealth. Anything said with an English accent always sounds smarter, at any rate. But he was a very strong witness, I thought, from outside the courtroom. I don't know what Sue thought inside.
Yeah, absolutely. From the presentation standpoint, you know, in the beginning, all of this, what this is and that, you know, it's hard for us to understand. We're just regular people. I always wonder if the jury is thinking, oh, my gosh, I ever thought about how my cell phone works. But with the presentations, the PowerPoint, not overdone, very simple. At first, when they put a map up of where John O'Keefe's cell phone phone went, I was a little concerned there were no landmarks, right? There's no Route 95. Right. But then I realized what they're doing is they were focusing in on just what we needed to know and not distracting the jury in another way. So I thought it was a very effective. If anybody ever needs to present some complicated information to people, this was a great model to do it.
What a difference, too. A stark contrast from what we saw in the first trial.
Absolutely.
Where it was very confusing, very convoluted.
Google Maps, aerial maps were used with trees. It was all very confusing.
It was very confusing. Okay, so speaking of the first trial, compared to the first trial now, Whiffen was called as an expert early this time around. Last time, he was way down on that list to be called to the stand. And importantly, we should note that during opening statements in the second trial, both sides made a clear point to say they would bolster their arguments with science and data. This digital expert, he told the court that he believes, based on the data he extracted from O'Keefe's phone, that John never made it into that house at 34 Fairview Road. How do you argue against something like that? Michael, is this shaping up to be a battle of the experts?
Yes, it is.
Okay.
But that image of all the dots, relatively close proximity to the flagpole, are going to be very difficult to overcome. Now, what they'll attack is the precision with which those dots are laid out, because even he acknowledged there's many meters between where that body or where the cell phone may actually be and where that's represented. So
Right.
they'll play that to a greater extent on cross, is the imprecision with the locations precisely of some of those dots. They want to try and get the phone inside the house at some point.
Or they're just talking about the cell phone, remember. They're not talking about John O'Keefe, right? So if I'm on the defense, I might say, well, he dropped his cell phone, and his cell phone stayed there, and he went in the house. And then I might argue, if I was on the prosecution, then he came out and just happened to land on the cell phone. And then I would say, well, they said they picked the cell phone up. We don't know for sure where that cell phone was when it was picked up. So I think the difference between having where the device was, the history of the device, versus where the history of where John O'Keefe actually was, is what's going to come into play.
And keep in mind, it's Carrie Roberts that said she picked up the phone from under his body, who now we're going to talk about later in the show, but now has admitted to lying under oath already. So I would imagine that that's going to be
a miscommunication, she says.
Right. She said it was unintentional.
Yes.
Unintentional. Okay, so jurors only had half a day, as I mentioned off the top. After that jury was dismissed for the day, though, court resumed with questioning of a possible defense witnesses. And I say possible because these are gentlemen that we've heard from before. They are ARCCA witnesses. That's the crash reconstruction firm that was originally hired by the U.S. Justice Department to investigate, well, their now closed federal investigation into O'Keefe's death. The testimony hugely important to Karen Reed's defense team, because in that last trial, those experts flat out said O'Keefe's injuries were not consistent with having been hit by a vehicle. Prosecutors right now working feverishly to prevent those two doctors from taking the stand. The main reason here is because the Commonwealth has suggested that the ARCCA experts have a closer relationship than we realize to the defense. That was a big focus of today's voir dire, which at times got really tense. Take a look at how this played out.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone and the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
Okay, that was just a snippet, a tiny bit of today's questioning, peppered with objections. Special Prosecutor Hank Brennan shouting at the ARCCA witnesses. Sue, you were in the courtroom for this.
Actually, wasn't in the courtroom for this part.
Okay.
But I can tell you that when his voice goes up in the courtroom, and he was not as loud as he was here as he has been in early, it fills the room. Like he started today's questioning this morning with a louder voice. I think probably because people on YouTube were complaining they couldn't hear him so well because of where the mics are. He has a very robust, full-sounding voice, so I can imagine how much this filled the courtroom.
Okay, that was just one of the heated exchanges between Brennan and Dr. Daniel Wolf there. Here's another one. This one happened at the tail end of Dr. Wolf's questioning. Watch.
I think you might be confused. Again, our role for this round...
I don't think I am.
Objection, Your Honor. You should be allowed to answer.
I don't think I'm confused. I'm talking about trial 1.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's not what I'm asking
we have
you.
provided everything that he would need to evaluate the testing that we have done.
All right, so Michael Coyne, I have to ask, is this normal to see such heated exchanges and to hear a prosecutor raise their voice, almost yelling at the witness at several points here? Is this normal?
It was much closer to the cross-examination of the defendant or the culprit. So it was intense, it was combative, and no, it's not normal for him to have used such an angry
tone,
combative tone. But you've got to remember a couple things about this that's pretty basic. Surprises aren't supposed to happen at trial. Matlock and suits are not real life. And so because of the rules of discovery and the ethical obligations, you have an obligation to turn over information. And what they're saying is the information hasn't been turned over, and not only that, it's been destroyed. And that's the other thing, basic thing to remember. Lawyers and their clients do not destroy evidence. You certainly don't destroy evidence that's helpful to you. And again, there are rules that prevent that. He's angry, and it was clear from the tone, it was clear from the manner of questioning that he believes that the rules have been violated. As the judge said, that they have, in fact, created some abuses of Rule 14. So we'll see what happens as a result of
that. It would make sense, right? If you feel the other side is cheating, then that anger is justified, if you are correct. The ARCCA experts were essential to the Karen Read defense last time around. But there's a chance now that the jury isn't going to hear from them at all this time around. In fact, Judge Cannoni banned the defense from even mentioning them in their opening statements just last week, potentially because she didn't know if they were ever going to be coming to the stand. What are the odds that she prevents them from testifying altogether? And if she does that set up grounds for an appeal right there?
On the last point, yes, absolutely. It would set up additional grounds for appeal. She has others as well.
Right.
But the odds, that's a tough one to say because, frankly, I think there are a lot of judges that would have sanctioned them much more severely for these abuses, especially the destruction of all of the information that's a background that the prosecution certainly would have used for cross-examination. I think in this case, though, she's hard-pressed to take such a draconian step because it undercuts her defense significantly. I think she may limit the areas in which they can testify to, but I don't see her precluding them completely, although I do think there are a number of judges that would do just that.
Emil, some of the jurors have reported, we've heard directly from one and secondhand from others, that they thought that the ARCCA guys were an insurance company, hired by an insurance company. So they were skeptical of their testimony, and some of them sort of said, well, we don't know what to make of this because we don't know why they were doing this investigation.
Right.
So it's a brand new trial. We don't know how much impact they'll have with these jurors if they know why they were investigating, or they actually come in with a potato gun that actually works, that they can actually show the evidence.
And they were skeptical before they knew that these are paid witnesses. This time, they certainly will know that.
Right. And I did think it was worth mentioning the potato gun was the only form of a smile I saw on anyone's face in the courtroom today.
You know, when you're Irish American, everything's about the potatoes.
Goodness. All right, Sue, Michael, thank you both. Don't go anywhere. We've got more Canton Confidential, the Karen Read murder trial coming up after the break. Coming up next, though, her legal team reached out, but the Supreme Court is putting its foot down. In regards to Karen Read's request for an appeal, they are saying no. Stay with us for more on that. And we're going to get to some viewer questions as well. We'll be right back.
Don't miss any of the Karen Read murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
All right, so we're back with the latest setback for Karen Read's appeal. She has spent months fighting to dismiss 2 of the charges she's facing, including the most serious of which, second-degree murder charge. She argues that the jurors in her first trial actually acquitted her, but didn't fill out a verdict slip. Read's defense team made a bid to dismiss those charges soon after that mistrial was declared back in July, after they heard from a juror who gave them the information that they had all voted to acquit. Well, in August, Judge Cannoni rejected that request. The Supreme Judicial Court did the same. That happened in February. Then in March, just a month later, a federal court declined to intervene on those double jeopardy grounds. So this month, Reed took her appeal to the nation's highest court, the U.S. Supreme Court. But today, we learned the court has decided not to take up that appeal. Today, Reed reacted to the court's decision.
Karen, any reaction to the Supreme Court not taking up the case?
Let's go.
Don't fight on. Nothing's breaking me, Matt.
Okay, so let's bring back in Michael Coyne, Sue O'Connell. The court made its decision after holding a hearing on Friday. Is the court's decision a surprise to either of you?
No.
No. Very few. That's it. No, very few cases.
Yeah.
Lots of cases get that far to the Supreme Court. Very few cases are heard. You think about, what is it, a couple of hundred? They actually.
Here, it's probably less than that.
Yeah, so it's not surprising. I will say this, though, Mel. If people are upset about this and think, well, you know, the more you learn about how the jury deliberated, maybe there should have been a better instruction. Elect lawmakers to change the law and say that the judge has to ask for a polling, or put a ballot question out.
Because in some states, the judge does have to ask
you don't
the
have
jury
to rely
be
on the Supreme Court. Take matters into your own hand and change the law.
Michael, is this the end of the road for her appeal, at least for now?
Yes, on double jeopardy, yes. But assume she's convicted, she still would be able to raise the issue. But the problem is, in Massachusetts, that issue is over. We had a unanimous decision by our Supreme Judicial Court. No chance of success here. Could she renew her habeas petition in federal court? She could. But the reality is that case never had legs to begin with.
Okay.
She ought to focus on the errors that happen at trial as she sees it and really plead that case if she is convicted on appeal.
That's where you think they'd be better to focus their time?
Yes.
Okay, fair enough. Let's get to a viewer question. A lot of you reach out to us, sending us questions. We've been getting a lot of them. We want to take a moment to answer some. So one of them centers on Carrie Roberts. She was with Karen Reed when they found John O'Keefe's body in the snow back in 2022. And last week, she was back on the stand and admitted that she lied under oath about the defendant telling Jennifer McCabe to Google hypothermia. Here's a clip.
And that was a false statement, wasn't it?
Technically.
Technically?
Yes,
It's
technically.
Like being a little bit pregnant, Ms. Roberts. What do you mean technically?
Technically, I was under oath, and I did not hear Karen asked Jen to Google it.
And yet under oath.
But I knew it happened at that time.
And yet under oath you said you did.
Correct.
And that was a lie, correct?
Objection.
Was that a lie? Did you lie?
I did not intentionally.
But you did.
And
not intentionally.
Yeah. Okay, that's the end of
Understood
this.
the question, Mr. Jackson.
Okay, so Andrew wants to know, if Roberts lied to a federal grand jury, despite it not being intentional, can she be charged with perjury? What do you guys think?
Yes, if it's material to the case, and we know it is with respect to who made that search and under what conditions it was made, she could technically be. The question is, would the federal court decide, or the U.S. attorney decide, that it's worth pursuing? A lot of times people misspeak. They don't tell the entire truth when they're questioned. You don't always see perjury charges brought.
You know, and how many opportunities did she have to correct the record is the other issue, right? You know, we know that from memory experts, every time you retell a story and tell something that happened to you, it's not the same story. It changes and it changes and it changes. But if you knew that you were saying something that was factually incorrect and then it became the basis of a case and you knew it, was there an opportunity to correct it? Did she tell anybody else that she misspoke or misunderstood? You know, giving her the benefit of the doubt, those all come into play, I believe.
And how many times she'd testified to that since as well, I would imagine. Okay, so let's turn to our next viewer question. Robin is curious, what will happen if at the end of this retrial, Karen Reed is found innocent? She asks, if Karen Reed is found innocent, do you think they will try someone else for the murder, or do they just let it go? What do you both think of that? With that possible outcome in mind, where would they go?
Well, she can't be found innocent. She can be found not guilty, saying that the Commonwealth didn't meet their burden of proof.
Okay.
But here's the problem.
That's an important clarification, too.
It is, because the burden rests on the government completely, and it's a high burden. So she could be found not guilty. Would they go forward with someone else? unless there's extraordinary evidence that comes forward, because whoever else might be charged is going to say the government, at least initially for 2 years, 3 years, 4 years, through two massive trials, said it was that defendant who's not sitting in the courtroom anymore.
And they were certain of it then.
And they were certain.
And remember, the John O'Keefe case is closed. Right. When it comes to the issue of the state police investigation. They have decided, they have closed the case because they have brought a suspect to trial. So there's no active investigation. They would have to totally reamp and get going again, and that's unlikely. Very rarely does that happen.
All right. Sue, Michael, thank you both so much. Really appreciate it. And thank you at home for sending us your questions. If you have more questions about this case, please keep sending them our way. We've got the email up on your screen right now, canton.confidential@NBCUni.com. We'll answer as many questions as we can. And remember to join us here on Canton Confidential, the Karen Read murder trial. Every weeknight at 7, we'll have a full recap of the latest developments from court, as well as legal analysis, as always. Plus, episodes will be streaming on Peacock. You're watching Canton Confidential, the Karen Read murder trial.